Does anybody care about censorship anymore? Does anybody care, or is it totally old news that no one wants to hear? We've just accepted that the government and tech companies are working together and we're just moving on. We just accepted and moving on. We're living in a post-COVID world. No one cares. That's what we're going to be talking to Dr. Aaron Kheriaty about today in regards to the Missouri v. Biden case. He's a plaintiff in it. This is a headline that he's going to break down for us. Supreme Court rejects challenge to Biden administration's contacts with social media companies. This came out a few weeks ago, and if you were watching Bill Doris and I, you were watching us on our show breaking down the media coverage. One thing that we discussed was how a lot of the headlines made it sound like the Supreme Court took on the merits of this particular case, which argues that the government essentially is using the tech companies as an arm of its censorship regime. So it's not just the tech companies with their little arbitrary rules and the community guidelines making up their ideas for what's safe or unsafe on their own terms. It's the government that's pressuring them to do so and thereby violating the First Amendment rights of people using the social media platforms. The headlines make it sound like the Supreme Court said, you know what, it's okay for the government and the tech companies to have this kind of relationship, when in reality, that's not what happened at all. So we're not just going to be talking about the case itself, but also the media coverage and what really happened here. And as always, how to be a better consumer of news and understand how this stuff goes down. A lot of these articles you had to read very far down in order to see that, in fact, the Supreme Court did not actually make a decision about the merits of this case, that it was a standing issue. If you have been watching this case over the last couple of years and you just eat a lot of donuts because it really stresses you out, then you might want to try out my liver detox. If you go to getliverhelp.com/Alison, this is a totally natural product put together by naturopaths and allopathic doctors alike. We've got turmeric, beetroot, dandelion powder, artichoke extract, ginger powder, milk thistle, alfalfa powder, black pepper. A lot of great stuff in this, and it will help your liver just get rid of all the nasty stuff that we Americans honestly are eating way too much of. And I cannot encourage you enough to get off of that stuff. Processed food, sugars. I cut all of that a few months ago, and I can't tell you how much better I feel. But anyway, if you want to give your liver a little bit of a boost, this stuff is great. It helps with burning fat, flushes toxins, cleanses your liver, helps with energy for somebody who's got chronic fatigue, improves digestion, helps with nutrient intake, and even if you've got skin issues too, helps with that too, like eczema. So go to getliverhelp.com/Alison. You'll get the bottle that I'm holding right here, and you also will get a free bottle of their omega-3 fish oil, and you can take both of those every day like I do. Getliverhelp.com/Alison. Okay, we are going to check out this article. I'm going to bring Dr. Kheriaty in right now. Great to see you. Welcome back, as always. All right, Dr. Kheriaty, as we were just discussing, Supreme Court rejects challenge to Biden administration's contacts with social media companies. And it does kind of, for me, I don't know about what you think, send this message that the Supreme Court has given a green light to the government to have these contacts with the social media companies to say, we don't like this information, and they should be able to, we would call it collude. They might say, just talk, just communicate with each other. There's no collusion when they're just friends. And so could you first tell us, before we get into like all the parts of the case that we can update people on, tell us about what actually happened. What did the Supreme Court decide?
Yeah, so a more accurate headline, Alison, would be Supreme Court delays ruling on this case, because essentially what the court said was that we're not going to rule on the merits of this case. We're not going to look at the record in this case. That was the majority opinion. There was a very important 3-judge dissenting minority opinion that actually did look at the record and did opine on the merits of the case. But the majority opinion basically ruled on a technical issue known as standing. And what standing means is that even if you have an unconstitutional law, or even if you have government officials, in this case, engaging in unconstitutional behavior, it's not the case that just any citizen can bring a case to court. Citizens have to demonstrate to the court that they have been personally harmed by this law, or that they have been personally harmed by this behavior in order to bring a case before the court. And In this case, there are 2 states, Missouri and Louisiana, and 5 private plaintiffs, including myself, that brought the case to court. And the court, I think, rather implausibly ruled that neither the 2 states nor the 5 private plaintiffs have standing to bring the case because we cannot yet prove definitively that the censorship we endured, which the court doesn't deny that we were censored. The court doesn't deny that my first interview with you was taken off of YouTube.
Mm-hmm.
What Justice Barrett and the majority opinion says is that we have not yet proven that that censorship was directly due to the government. It may have been due to the social media companies. It may have been initially due to the government, but we can't prove that the government's going to do it again in the future. And so we lack standing to bring the case, and which does not end the case. It sends the case back down to the district court for us to do additional work on discovery to try to establish that we have standing. So the case is not over. We're back at the district court. The injunction, which the district court had granted and which the circuit court had upheld, the injunction against the government, is no longer in effect because of the Supreme Court ruling. But the case is not over. So what we're doing now is requesting more information on government communications, and we'll have more depositions of the various defendants from the various government agencies involved in censorship. And from that, we will try to more definitively establish that at least one of us, which is all we need, and probably that plaintiff will be a woman named Jill Hines, who I think very clearly has standing in this case because of the way that she was censored by Facebook. The 3-judge minority at the Supreme Court also agreed that at the very least Jill Hines had standing. But we'll try to more definitively establish standing so that we can move forward and move toward a final ruling that will put a stop to the government censorship. The other, I think, really important wrinkle in this case, and the other reason why this case is very far from over, and in fact, the other reason I think that this case is going to be right back at the Supreme Court very soon, and the court's not going to be able to punt on an issue like standing. They're not going to be able to just temporize or delay based on this kind of technicality, is that before the case went to the Supreme Court, Robert F. Kennedy Jr., which I'm sure most people know, is an independent candidate for the president of the United States, filed a very similar suit in the same Western District of Louisiana that more or less parallels the Missouri v. Biden case. And the judge has the discretion, if there are 2 cases filed at the same time in the same court, the judge has the discretion to basically combine those cases, which Judge Doughty did in our case. So Missouri v. Biden, or now known as Murphy v. Missouri, is now combined with RFK Jr.'s case, which means he can use all the documents that we already got on discovery as part of his evidentiary record. And we can use, so to speak, his standing as a plaintiff to advance our case. And the reason that that is important is that in several of the documents, several of the email communications that we got on discovery show very clearly that RFK Jr. was specifically named, that specific posts of his were called out by government officials. And basically they were telling Facebook and telling Twitter, take down this specific post by RFK Jr. related to vaccine injuries or related to speculating on the cause of death of baseball player Hank Aaron. And then we saw the social media companies, at least in some cases, act upon those government directives and remove those posts. And so what we have now is a plaintiff who very clearly has standing, and we have all the breadcrumbs, we have the paper trail showing that, yes, indeed, he was directly harmed by the government's action. It's I think, beyond reasonable doubt, irrefutable. And so once that injunction in his case goes into effect, we're going to see the same progression. Basically, Judge Doughty had an injunction already prepared that was being held in abeyance while we were waiting for the Supreme Court's ruling. Now that the Supreme Court has denied the other plaintiffs, including myself, standing on the injunction, RFK Jr.'s injunction is going to go into effect. It's going to be appealed by the government to the Fifth Circuit. The Fifth Circuit, we all anticipate, is going to come to the same ruling that they did last time, upholding the same injunction. that they upheld last time. The government's going to appeal again to the Supreme Court. And before long, perhaps, within a few months, once the court is back in session, they will be faced with this same case, with the same evidentiary record, with a new plaintiff, RFK Jr., whose standing will be, I think, impossible to deny. And the court at that point will be forced to rule on the merits of the case.
I want to watch a little of their coverage in a second, but I want to get your opinion first of the quote they have from Justice Barrett. The plaintiffs rely on allegations of past government censorship as evidence that future censorship is likely. Are they saying then that, okay, they're calling them allegations, so they're not saying it definitely happened, but quote, they fail by and large to link their past social media restrictions to the defendant's communications with the platforms. Thus, the events of the past do little to help any of the plaintiffs establish standing to seek an injunction to prevent future harms. What I read there is somebody didn't convince them that the Biden administration's communications with the tech companies is what caused the social media restrictions. And that seems very central, obviously, to this. When I was talking to a journalist who's been covering this for quite a while, before the decision came down, but when the oral arguments were being broadcast, we could hear him. He made it seem like, too, even though we were critical of the mainstream news coverage of it, but he kind of made it seem like it just didn't seem like it went so well in court, and that the lawyers didn't make a strong enough case. And I think some of us were sort of confused by it. Like one thing we didn't hear was the case that the government spreads misinformation and propaganda. And so I don't know. What did you think about the actual arguments? Do you feel like it was a solid case? Do you think that quote from Barrett in the article is not necessarily an ominous one that you guys could pull it together in the final hour and it'll all be okay? I don't know. There were a lot of concerns about.
Yeah, I agree. I think the oral arguments were weak. We had a rookie solicitor general who had never argued a case before the Supreme Court from Louisiana arguing this case. The lawyer that should have argued the case, in my opinion, the opinion of all the private plaintiffs, was John Sauer, the former Solicitor General of Missouri, who remained involved in the case, working for the Louisiana Attorney General's office. But basically, for political reasons, the new Missouri AG decided that he didn't want Sauer arguing the case. And I think John Sauer would have made a stronger case than the lawyer who ended up arguing the case. And that's unfortunate, but ultimately the case has to be decided on the record. The case is decided on the briefs that are submitted to the Supreme Court. It's not ultimately decided on the oral arguments. So if we end up at the Supreme Court again, I anticipate we will have a lawyer who's prepared to give stronger oral arguments. But at the end of the day, we have an evidentiary record that's tens of thousands of pages documenting egregious examples of government coercion that I think will be impossible for the court to ignore if the court actually has to deal with the record. And the judges who have actually dealt with the record, the district court judge and the 3-judge unanimous panel at the Fifth Circuit, have all basically said these violations are clearly unconstitutional. They're clearly egregious.
If you're somebody who's very bored, you don't know why you have a cell phone because you've got nobody to call, now you do. You can text Alison with 1L to 989898 and find out everything you've ever wanted to know or not know about transferring your IRA or 401k into precious metals. BIRCH Gold is now one of my sponsors, and thankfully they stuck around for another month because people like you texted them. You get your free info kit on gold. It's no obligation. They've been in business over 20 years. They've helped tens of thousands of people decide whether this is right for you. You're concerned about the economy. You're concerned about the economy post-election. You're concerned about the economy because of avian flu. You're concerned about the economy because of censorship. You're just somebody who wants to live under a rock and, pretend like none of this is happening. You can put your gold under that rock by texting Alison to 989898. And again, this is just a great way to support the show and also get the information for somebody who's been considering this for a while. Thanks to BIRCH Gold. And you can send me real mail. I have a P.O. box is 3355. Danelle in Florida, 34432. I love getting all the cards. Got this nice little B bookmark here for the B attitudes, and also because we might have beehive. I'm looking into it, even though I'm technically allergic, but that's okay. PO Box 3355, Danelle in Florida, 34432. Send me your loose pocket change. Send me a winning lottery ticket. Do not send me anything edible. I will assume you're trying to kill me. And please keep it kid friendly, because the producers open the mail on the way home. They love doing it. We just sent out a huge batch. Here's an example. We just sent out a huge batch of producer artwork. The producers work very hard to send you thank you artwork. So you will be getting that in the mail. Really appreciate everybody who supports the show that way. One other question over on locals. Does this decision, Gregory asks, on standing have broader application to other cases, or is it just case specific?
So the decision as to whether these 7 plaintiffs in my case have standing is case specific. Could the criteria outlined for standing in this case potentially affect other cases? Yes, it could, unfortunately. The minority dissenting opinion basically argued that the majority opinion established a new and untenably high standard for standing in a case like this. That basically it's not enough to say I was censored, and I was censored on content of the type that the government was clearly censoring. That should be enough to establish standing. This very high threshold that they've set could potentially affect other cases that are trying to challenge government censorship in the way that our case is. Again, ultimately, I don't think it's going to be able to stop those challenges. And the reason is, even if the government stops naming names from here on out going forward, we already have a very substantial record in our case that can be cited by other cases to basically bring their cases forward. So I think it's created more difficulties than it should. And the 3 dissenting justices expressed, concerns in that regard. But ultimately, I think we're going to be able to clear even this very high threshold, because the evidence that we have in our case is so egregious, and individuals were named, and specific posts were flagged and called out, and then subsequently throttled by the social media companies under pressure from the government. So I think there's just no way around that evidentiary record. And like I said, the court's going to have to face the actual record in this case. They're going to have to rule on the merits of the case eventually. And I think that's probably going to happen sometime in the next term with a ruling by next June.